If you are a listener or viewer of this podcast, you have probably seen the excellent Jenna Ellis talking about the law. She is the director of the Dosent Policy Center, a contributor to the Washington Examiner, the Federalist, and the Daily Wire. She also has her book, which is a lot of what we're talking about today, The Legal Basis for a Moral Constitution, a guide for Christians to understand America's current constitutional crisis. I read it and I talked to her about it. Here it is. Jenna, it's so nice to finally meet you.
Yes, thank you. You too.
Yes, it's great to have you here. And I finally get to talk to you about your book, The Legal Basis for a Moral Constitution, which is really interesting. Before I talk to you about that, though, I want to ask you a little bit about a comment you made on the show a while back, that you yourself had kind of lost some faith. You had had a crisis of faith, had become kind of a feminist. And how did that happen, and how did you come back?
Yeah, that's a great question. So I grew up homeschooled all the way through. I had parents who were absolutely, and they still are absolutely amazing. And I grew up very founded in the Christian worldview, understanding truth, being a Christian. And then I went to law school. And I went to law school with the intention of being a career prosecutor. That's what I wanted to do. And law is taught in law schools today as whatever the legislature sets is legitimate. So it's completely arbitrary. Whoever is in authority now, then they can enact whatever they think is okay. And whatever is not permitted today could be permitted tomorrow. Whatever is prohibited today, we could be fine with tomorrow. And so there were no objective truths that were taught in law. And so I didn't get a sufficient answer from professors of mine who actually were Christians about how we can go into the court system today and advocate for objective truth and morality. And that really spun me into a crisis of faith, because I had loved law. I upheld justice as probably the prime virtue, which now I understand truth and objective truth is really what we're striving for. And so that really bifurcated to me my faith in one corner, but then the law in another. And so I didn't see how, well, why shouldn't we have civil unions? Why shouldn't we do all of the social issues? Why doesn't the left have a point? And so I would have identified, and I did, as a feminist, and saying, these types of social issues, there should be no moral basis to the law. And that question kept really nagging at me. Mm-hmm. And so once I got into practice, I had to find out for myself, what is a real answer to this question? And so through my study and research for about 5 years, that became why I wrote this book, is to actually have a genuine answer that's better than just, well, whatever the legislature says and whatever civil society decides today that they want, now that's okay. And I wanted a more satisfying answer. And so the curve back, if you will, into faith was through understanding where law's origins are from and where morality genuinely comes from.
Really interesting. I mean, one of the things I really liked about this book, and the minute I read it, I thought, gee, I haven't heard this argument before, was you say that when we discuss the Judeo-Christian basis of our society, we always get into an argument about whether the founders were Christians, and many of them were deists, and many were Christians. But you say that that's not really the issue. The issue is whether they were lawyers. Why do you say that?
Yeah, so if we look at even law today, when I go into a courtroom and I, as a prosecutor, and I would say we need to enforce this particular law, there is no defense or argument about the people who enacted that law, whether or not they were sincere Orthodox Christians. That's not the basis of legitimacy in law. It matters, where does the authorization and authority to enact those laws legislatively derive from. And so in looking at the profiles of our founding fathers and what they actually did in our legal documents, the Declaration of Independence and the Constitution, it doesn't matter as much whether or not they were sincere Orthodox Christians in their personal lives. It matters, what did they put into our legal documents so that 200 plus years later, we can look back and say that is the basis of our law.
That's what they meant, because lawyers kind of have a language. They know what each other are talking about all the time, right? So they were very specific. Explain to people, because a lot of people do not know this, what is the relationship between the Declaration and the Constitution? Because people think, well, the Declaration just said we're free, and then the Constitution is the law, but that's not really true, is it?
Right, it's not, because the Declaration was the first legal document that essentially effectuated our national sovereignty. And so a lot of people will say today that the Declaration is just this, wonderful historical document. We celebrate it on the 4th of July, if they even know that.
Right.
But really the Declaration set out our worldview statement, and it legitimized why our revolution and our separation from England was an exercise of legitimate authority. And so when they started out and they said, we hold these truths to be self-evident, they were saying truth is discoverable. All men are created equal. They're endowed by their creator, not their government, with certain unalienable rights. And among these are life, liberty, and the pursuit of happiness. And that was their premise, to say this is the only proper role of government, is not for the government to give us our rights, like most of the other societies today, and certainly England then, but rather saying that our unalienable rights are what the government is designed to preserve and protect. So they provided in the Declaration the only mandate for government. And as really good lawyers, they appealed to the highest authority of the law that they knew, which is the supreme judge of the universe.
Because they were going over the head of the king too, right?
Exactly. And that was their name for God in the Declaration. And so just like, for example, if you and I had a contract dispute, right? And we had, there was a contract that you're going to sell me your leftist tears mug for, and you will. Yeah, I want to take that with me. And you're going to sell that to me for $500, right? Because it's so amazing. And then 200 years later, our heirs and our posterity are going to litigate that contract. Nobody is going to come in and say, oh, well, the terms of that were so completely different. How could we possibly know? This evolves over time. Nobody in the contract world will ever say that the terms didn't mean what they meant to the two parties that entered into the agreement. So why is our Constitution somehow just this magical document that we can say, oh, well, the terms just evolve over time, our rights evolve over time? They're not looking at the 5 pages of the document.
So they are establishing in the Declaration that the authority for the Constitution is the authority of the supreme judge of the universe. But they obviously didn't mean for the church to be that judge, right? They meant, when they said God, they meant God, right? What does that mean in real terms?
Yeah, so that's a question I often get is, well, you're advocating for a theocracy, Jenna. Well, that's not true, because if we look at the reality to which we're presented, and we also look at Scripture, God has ordained 3 spheres of government: the civil government, the church government, and the family government. They have very different delegated authority from God himself. If we look at Romans 13, then the civil government is supposed to bring about justice in society and can carry the sword, meaning capital punishment. Capital punishment is not given to the church or the family, thankfully. A lot of families, a lot of people would say, thankfully, my parents didn't have that.
Oh, yeah. I thought I had it in my family.
Right. So we see they're very different authorities. So that's what Jefferson meant by the separation of church and state, is a separation of delegated powers, which is what our founders recognized. Delegated powers to government have to be under the authority of what God's design and purpose for government is. And that doesn't mean that Christians or people of faith can't participate in all 3 spheres. It's just that the church's authority structure and how what their role is in society and in humanity, just like the family, is very different from the civil government.
But when they talked about nature and nature's God, they meant that God's will was discoverable in life, right? That it was not necessarily had to be based on Scripture according to the documents. It could be natural law, essentially, those things that we know to be right and true.
Absolutely.
You talk about that idea being replaced by the idea of the social contract. What does that mean?
Yes, so C.S. Lewis actually has a great definition and argument for what natural law means. And if we look just at the reality to which we're presented, there are certain things and legal principles that we just can't avoid because we are in our reality. Right. And so, for example, and one of the examples I give in my book is if Congress tomorrow said, it would be really great, let's just pass a resolution that says that gravity no longer applies. We all can fly because it's too expensive to go transatlantic. We would all laugh, right? And we know that they don't have that authority. They are bound by the rules of the universe, and God, for his own sovereign purposes, ordained and established our reality. And so what has been replaced in thinking is to say that the origin of law is not reality, but man himself is the divine lawgiver.
It's just an agreement between folks.
It's just an agreement. And so if we look at where does law come from, it either has to come from man or something outside of man, meaning God. And we can have the conversations about who God is, obviously. But when we're looking at what the replacement for the social contract theory is, what our society today would like is just the ability of contract and to say whatever man consents to, and this is what they teach in law school, law is totally arbitrary. If Congress wants to say this is abortion is fine, it's legal, it's permissible, they can do that. They have all authority to determine morality on their own whim. And so the social contract theory is based in the worldview of secular humanism, basically meaning that man is the sovereign and we can do absolutely whatever we want and we can define morality on our own terms. And so people use that term, we the people, to mean, oh, we the people are the moral lawgivers, we can determine our own reality. But in fact, we the people in the Constitution, in the preamble, is referring to the very same people in the Declaration that are endowed by their creator, not their government, with those unalienable rights.
Among them, the right to life, right? So that is actually right in there. Is said as natural.
And our posterity as
Right.
well. When we talk about in the preamble of the Constitution, it refers to ordaining and establishing this Constitution for ourselves and our posterity. We still, in American law, in property rights, we will just have heirs apparent because we understand that there may be future children born to a certain family
Right.
that will then inherit some of the property. And so even before they're born, they have property rights. How much more should they also have the right to life?
So your argument is that there has been a concerted effort by the left to replace natural law with social contract law, and that this has come up in a number of cases through the years that have actually managed to kind of do this, to replace the one idea with the other in our constitutional law. Am I giving a fair description?
Absolutely.
So let's talk about some of the cases. What would you say are some of the cases that people don't know that have affected that exchange?
Right. So when people are looking at a lot of the cases that they disagree with, they're looking only at the outcome. So for example, Roe versus Wade, everyone knows and they disagree or agree
Right.
with the outcome of that case. But what they're not looking at is what led up to that and why does the Supreme Court think that they have the authority to determine those types of outcomes. So with the rise of the sexual revolution and with this idea that man can determine his own reality and that our rights, rather than being pre-political, unalienable before our Constitution. And if you think about that, the Declaration was referring to rights in 1776. The Constitution wasn't ratified till 1787. How could they possibly be talking about
Right.
constitutional rights? And so what happened with the rise of the sexual revolution is that the progressive left wanted to legitimize their immorality. And they had rejected the church sphere as an authority and the family as an authority. So they're only left with the civil government. And so with that, they wanted the so-called right to contraceptive, to abortion, to same-sex marriage, all of those things. But that's not actually in the Constitution. The Constitution only gives powers to the government, limited powers, to operate to preserve and protect our fundamental rights. So what happened in 1965 with a case called Griswold versus Connecticut, it was one of the very first contraceptive cases, and it led to Planned Parenthood versus Casey, Roe versus Wade. All of the sexual revolution cases have outflowed from that one case, which the panel of justices looked at the Constitution and said, really, we don't have any authority to determine this. But what they did is said that there is a so-called vast penumbra in the Constitution where we can literally read between the lines of the text of the Constitution and find rights that emanate from the Constitution that then we can regulate and we can enforce at whim. So it was entirely a legal fiction.
And what was the issue this was dealing
It was a
with?
contraceptive
It was the
case.
contraceptive one. Okay. Now, you talk about the case where we got the penumbras and the emanations, which I love. I always thought that was so creative. And that really does lead to Roe v. Wade. And not, I don't even know if it leads to Obergefell, the gay marriage decision. That seemed to just come out of nowhere, out of Anthony Kennedy's ear. I mean, he just seemed to pull that out of his ear. Am I wrong?
Well, but it's a whole line of the progressive left wanting to use the judicial branch to legislate their activism and their agenda. And so as a conservative myself, what conservatism is conserving the rule of law, conserving the limited powers and the actual proper role of government. So unlike capital L libertarians that say government is essentially evil, its only purpose is to enforce and moderate contracts, right? That consent, that's still a secular humanist principle. But then the left will then say, well, big government should be able to regulate everything. Conservatism is not about a political party. It's about conserving objective truth.
So much of this, and you do point this out in the book, so much of this revolves around sex. Now, sex has changed because people have birth control. It has made people more free to make decisions. I can't imagine us ever going back to a world in which the states legislate against certain kinds of sex. Is it inherent in sexual freedom that we lose our political freedom? Are those two things related? Or can we have a world in which I don't have to care about what my neighbor is doing, which I deeply want? I deeply want not to care about what my neighbor is doing privately. Can we have a world in which we don't care about that and remain free as the founders intended?
And I think your question is to the heart of, can we legislate morality? And the answer to that is that we do every day. I mean, every single criminal law that's on the books is society's designation of what we believe and understand to be wrong. There is always a moral implicit understanding in our law of our society saying certain acts are prohibited. And so when we're looking at the sexual revolution and this whole idea that mere consent, and you have to be a person of the age of consent to say, you know, we're going to enter into this contract, that divorces any sort of moral component to that. And so the question becomes, at what point does the civil government have a mandate and an obligation to protect and preserve our fundamental rights, but then also with that enact justice in society? And so I don't think that those two premises are mutually exclusive. When you say that an individual should have liberty and freedom, that's true, but our liberty and freedom isn't the ability to do literally anything that we want. Our criminal law tells us that. Now, I have the liberty to make bad choices and accept the civil society consequences for those choices. That's what we do in court every day in the criminal context. But for the government to say we have to completely step out of any sexual issue is not enforcing and enacting not only justice, but also preserving and protecting certain rights. And so, for example, when we look at something like pedophilia, when we look at the progressive left, how they are wanting to separate this idea of personhood and say you're only a person after you're born. Well, if you do this, and Ben Shapiro talks about this really well, if you designate personhood at any other point than the time of conception, then there's no reason not to draw the line anywhere you want arbitrarily. So what's to stop someone from saying, well, personhood doesn't attach until 16 or 18. So now you're left with, there's no crime because love is love. And if a pedophile would go and perpetuate that act, well, it's not really harm because that child is no longer a person. So you can see how the understanding and the philosophy will get us so far down the road unless we understand the legitimate role of government.
Which would be, but it would have to be at the local level, right? I mean, the federal government is given no right to legislate our private lives.
Absolutely. And that's something where the federalism model, we have to understand that there's two dual arguments here. One is what can the government and should the government do? And what are the limited powers that are actually granted to the federal government? So the easiest way and the most proper way to overturn something like Roe versus Wade or Obergefell is to simply say that the federal government doesn't have domestic relations or healthcare as their ability to legislate, right, and to leave that to the state level. But then on the state, then they still have to go by the Declaration's mandate as well.
Okay. I don't have any more time, but I want to ask you one last question. What would you like to see conservatives doing to reverse the trend? Is that even possible?
That is a great question. And first, we need to be educated. We need to actually understand, like I did, I wanted to understand what is the genuine argument here. Because if it's just what I believe versus what you believe, that's not getting us anywhere toward truth. We have to understand, where does law come from? Educate ourselves, have not just some arguments, but have the best and most accurate and truthful arguments. So we have to first educate ourselves, then we have to get involved. We need to be involved in our government process. We need to be speaking on these issues. But then the best, and the last chapter of my book talks about the Convention of States project, which is a way that the state legislators can propose amendments to our federal constitution for the purpose of reining in the federal government's abuse and overreach. And so if the state legislators pass a petition in 2/3 of the states, then they can call a convention for the purpose, solely the purpose of proposing amendments. They have to be ratified the same way as congressional amendments. All of our previous 27 amendments have gone through Congress, then the ratification process. But what we've never done is call a convention of the state legislatures. And they're the ones that really need to be determining all of these social issues. They need to call a convention of the states, and they need to rein in the federal government. There's a great project right now called the Convention of States Project, conventionofstates.com. And that is for 3 different areas: for term limits on Congress, a balanced budget, and then also for judicial activism and overreach, for reform of the judiciary. And we absolutely could deal with some of these issues and some of these cases that we're talking about through a convention of the states.
Great. Jenna Ellis, the legal basis for moral constitution. Where do people find you? Where's the best way to look for you?
Yes, so I'm with the James Dobson Family Institute, and so you can find us at dobsonfamilyinstitute.com. There's a profile under the public policy tab, and my email address is out there, so if you have any questions, or certainly on Twitter or social media, now that you're following me on Twitter, yay, you can find me there as well.
All right, great. Thank you very much.
Thank you.
All right, Jenna Ellis, we will always have her back, and there's so much stuff going on about the Supreme Court. I'm sure we'll hear from her again soon. Good interview.